Our key concept is the same one as last time. The American Revolution's democratic and republican ideals inspire new experiments with different forms of government. But today we're focusing on after declaring independence, American political leaders create new constitutions and declarations of rights that articulate the role of the state and federal governments while protecting individual liberties and limiting centralized power and excessive popular influence. So we're going to talk about how a lot of state constitutions place the power, most of the government's power, in the hands of the legislative branch, the lawmaking branch, and maintained property qualifications for voting and citizenship, meaning not a lot changed after the revolution within the states in terms of the self-government. Strong state legislatures with weak governors and courts was that was the norm for many different states. In terms of their government. The goal of these state legislatures was to avoid tyranny, as the new Americans felt they experienced during the English rule. State lawmakers could create laws and represent the people. There was no strong law enforcement, no executive, or interpretation of the laws, very few strong courts. This was a direct response to the British Admiralty courts and people's mistrust of the court system, as well as a mistrust of royal governors and taxes and duties that were collected. Another example of state constitutions placing power in the hands of the legislative branch were the fundamental laws. The concept of natural justice and defense against tyranny was the precursor for the fundamental laws. This law is timeless and universal. Many leaders felt that this concept could be embodied in a law and would endure for ages, like the Constitution. So again, the idea of a government is to protect natural justice and defense against tyranny. The Articles of Confederation unified the newly independent states, creating a central government with limited power. After the Revolution, difficulties over international trade, finances, and interstate commerce, foreign relations, and internal unrest led to calls for a stronger central government. So the Articles of Confederation themselves, talk about that first. They were pretty weak. There was a weak unicameral legislature, a one-house legislature, with no power to tax, draft military, or regulate trade. There was a lack of a judicial and executive branch completely. Post-Revolutionary War, Congress needed money and they had to collect taxes from the state, but the Articles of Confederation did not give them power to tax. Many men fought in the war and were paid nothing, including George Washington. The Massachusetts farmers and veterans were in debt, and they were led by Captain Daniel Shays in a rebellion against the Boston creditors or tax collectors. Massachusetts wanted to collect a tax from these farmers. They had not worked on their farm because they'd been fighting in the war. They got no money from fighting in the war. So beginning in 1786 and lasting half a year, Daniel Shays and his rebellion threatened economic and business interests of the elites in Boston. The federal government could not intervene to stop the rebellion because they had no power to enforce laws or order or raise a military. This leads to a demise of the Articles of Confederation because everyone realizes that they are very weak. They do not give the federal government much power at all. Delegates from the states participated in a constitutional convention, and through negotiation, collaboration, and compromise, they proposed a constitution that created a limited but dynamic central government, and it embodied federalism, providing for a separation of powers between its three branches. When our founding fathers got together to create our Constitution, it was a top secret meeting because essentially it was treason. They were going to overthrow the government and create a new government by writing this new document. Within this new document, there's a bunch of compromises. The first is the Connecticut Compromise. This also is known as the Great Compromise of 1787. Roger Sherman of Connecticut came up with it. It established a two-house legislature. It was a compromise between heated arguments of small states wanting equal representation in the legislature and large states wanting proportional representation in the legislature. The small states, what they were arguing for was known as the New Jersey Plan. The large states, what they were arguing for was known as the Virginia Plan. They wanted one house of representatives. The Connecticut Compromise created one house based on proportional representation and 3/5 of slaves in the South counted as population for the southern states. One house was called the Senate that had equal representation from all states, regardless of population. Our next example is checks and balances. This was a principle of government where there were 3 branches empowered to prevent actions by the other branches that may restrict the rights of people or go against the Constitution. The legislature was created. It's a lawmaking body, and they can impeach executive or judicial representatives. The executive branch, the law enforcement body, can veto legislation passed by the legislature and appoint justices to the judicial branch. The judiciary branch, which judges the constitutionality of laws, can declare laws or executive actions unconstitutional. And that's how checks and balances works. Separation of powers was another major concept of this Constitution. The legislative, executive, and judicial branches all have different powers, roles, and responsibilities. They do not share powers, therefore no one has complete control of the government. And again, this is to prevent the tyranny that people felt had happened under English rule. And finally, we have our Electoral College. This is a process, not an actual place. Step 1, we select electors. There are 538 electors currently, divided amongst the states based on population. Each presidential candidate has his or her own electors that are selected by their party. Step 2, there's a meeting of electors where they select the president and vice president. Most states are winners take all. Step 3, we count the electoral votes, and Congress does this. You need 270 electoral votes to win. The goal of the Electoral College is to not give power to the masses, it's to give power to people who are informed about the government. This is something that many people feel is outdated, but many people still appreciate that we have. And the Electoral College has changed over time. We used to elect senators using the Electoral College, but we took that away with an amendment later on. Federalism. This is the last thing we're going to talk about in the Constitution. The Articles of Confederation set up a confederation, which is a strong state government, weak federal government. Britain had and has a unitary system. Power is concentrated in the central government. The federal government, or federalism, is a compromise where power is shared between state and national governments. And that's pretty unique to something we have here in the United States. The constitutional delegates have some power and roles for central government. Like the central government, according to the constitutional delegates, was given power to raise military, coin money, regulate interstate commerce and transportation. But some powers are reserved just for the states in this compromise of federalism. So states have sole control, or did, over education, issuing licenses, marriage and drivers and so forth, and running elections. Both state and federal government share some powers. Both state and federal government can pass laws, they can collect taxes, etc. And the second to last thing we're going to talk about is the Constitutional Convention compromised over the regulation of slave states in Congress and the role of federal government in regulating both slavery and the slave trade, allowing the prohibition of the international slave trade after 1808. The Three-Fifths Compromise was proposed by delegates at the Constitutional Convention in 1787. This idea is that the population of slaves, in the South especially, would count as 3/5 in total when apportioning representatives to Congress. Presidential electors and taxes are also affected by this rule. This gives Southern states a stronger presence in the federal government, but slaves still cannot vote in the United States at this time. The slave trade compromise and the Fugitive Slave Law were also decided upon during this Constitutional Convention. This is another compromise worked out by a special committee that decided Congress had the power to ban the slave trade, but not until 1800, and later that was pushed until 1808. And that was a vote to extend that date. In return for this new law, Southern states wanted other states to return escaped slaves. That led to the creation of the Fugitive Slave Law in 1793. It required seizure and return of runaway slaves who escaped from one state to another in federal territory. It also allowed any federal district judge or circuit court judge to decide the status of an alleged fugitive slave without a jury trial. The North strongly opposed this law. It made them very frustrated. They made their own laws that entitled fugitives to be given a jury trial. This leads to systematic assistance given to Black slaves escaping from South to New England or Canada, known as the Underground Railroad. And it leads to a growing divide between regions, North and South, in the newly created United States. It's the last thing we'll talk about. In the debate over ratifying the Constitution, Anti-Federalists opposed ratification. They battled with Federalists, whose principles are articulated in something known as the Federalist Papers, primarily written by Hamilton and Madison. The Federalists wanted to ratify the Constitution by promising the addition of a Bill of Rights that enumerated individual rights and explicitly restricted the powers of the federal government. Okay. The Federalist Papers, written by our Federalists, are 85 letters written to newspapers in the 1780s. These Federalists wanted to ratify the Constitution as is. They wanted every state to sign it, every state to join in. You needed 9 out of 13 states to ratify the Constitution, and the Federalists used the press to spread this message. The three authors of these papers, John Jay, our first Supreme Court Justice, Alexander Hamilton, the first Secretary of Treasury, and James Madison, otherwise known as the father of our Constitution and the fourth president. They used the pseudonym plebeius, meaning person or citizen. They wrote these essays to convince Americans that a strong central government, as set up in the U.S. Constitution, was necessary to preserve the Union and give the federal government power to act firmly in national interest. This was to replace the Articles of Confederation. The Federalist stance was that a weak central government with no executive or judicial branch or power to tax or power to raise an army was going to destroy the newly created United States. Therefore, we need to pass the Constitution quickly. But the Anti-Federalist would not agree to sign the bill or the Constitution without adding something to protect individuals, otherwise known as the Bill of Rights. These are the first 10 amendments added to the Constitution in order for any Anti-Federalist to ratify the document. These are written by James Madison. This was a response to calls from several states for greater constitutional protection of individual liberties. They prohibit and restrict certain powers of the government. Anti-Federalists said this would safeguard personal liberties and must be added. Even though the Federalists did not agree at first, the Bill of Rights was added before the Constitution was ratified. So what I want you to think about at the end of this lecture is which of the first 10 amendments are most important to you and which was most important to the colonists. If you guys have any questions, please let me know.